With Sean Diddy Combs being denied bail yet again, what's next for him? Can he try for a fourth time? I'm going to be breaking it down with former federal prosecutor Neama Rahmani. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. What's next for Sean Combs? That's the question. For the guy who was denied bail for a third time and will conceivably remain locked up at the Metropolitan Detention Center pending his May 2025 trial on federal sex trafficking and racketeering and prostitution charges, the question we're now asking is, can he ever get out of the MDC, the Metropolitan Detention Center? Does he have another chance at bail? I'm going to quickly set the stage for you to tell you where we're at. So, as we reported to you here on Sidebar, Combs was denied bail by the current judge overseeing this case, Judge Arun Subramanian. Did it right on the eve of Thanksgiving, Wednesday night. And that is a big blow to the embattled rapper and producer who's facing these federal charges that could conceivably send him to prison for the rest of his life. Now, the judge, in his order, was moved by several factors. Judge Subramanian wrote on page 1 of the order, "The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community." Now, first, aside from the allegations in the indictment that detail an alleged scheme going on for years where Combs allegedly abused, threatened, coerced women to fulfill his sexual desires, that he operated a criminal enterprise that was engaged in all sorts of illicit activity, putting that to the side, besides those allegations, Subramanian also cited the 2016 videotape of Sean Combs purportedly beating his ex-girlfriend, Cassandra Ventura, that was published by CNN several months ago, that, coupled with all the allegations in the indictment, is evidence of his violence. It's his propensity to violence, his dangerousness. Dangerousness is an important factor in a bail analysis. Second, Subramanian ruled that Combs presents a serious risk of witness tampering, obstruction, like improperly contacting a grand jury witness and trying to cover it up. Third, Subramanian says that Combs violated the Bureau of Prisons regulations in the MDC to obscure his communications with third parties, whether that be paying other inmates to use their phone access code numbers to make calls to people who were not approved on his contact list, or instructing family members and lawyers to add people to three-way calls. And while the prosecution said, this is clearly an attempt to improperly contact witnesses of the case or influence a jury pool, Subramanian, in his order, said, I'm not even going to make a determination on the content of those communications. It's just the fact that he violated BOP rules that matters. He broke the rules while in the MDC, while he was seeking bail, and when he knew the government had already alleged he was reaching out to witnesses and engaging in obstruction, and yet he does this? Subramanian says, and despite all that, he does this from behind bars? What makes you think he can be trusted on the outside? 4, and this was really interesting, Subramanian took issue with what he perceived to be Combs' lawyers, saying that they misrepresented to the court whether Sean Combs' legal pads in his jail unit were actually labeled legal or not. And that, again, was with respect to a separate inquiry on whether his rights were violated when photos were taken of those legal pads. That's a separate issue. But the idea is, can I even trust your lawyers, Mr. Combs? And by the way, Subramanian also cited the fact that Sean Combs' lawyers told a previous judge, hey, court, Combs didn't reach out to a grand jury witness in this case. But guess what? He allegedly did. So it goes back to this idea of, how can I even trust the lawyers to make sure that Sean Combs will do what he needs to do on the outside? Number 5, let's talk about Sean Combs' bail package. And Subramanian seemed to be entertaining the idea of pretrial release, because at a prior hearing, Combs' lawyers suggested that they would have this apartment ready in New York City, that there would be 3 private security members who monitor Sean Combs, that he would have no access to phone or internet, that he would have a pre-approved visitor list, there would be a $50 million bond. Subramanian wrote, the court doubts the sufficiency of any conditions that place trust in Combs and individuals in his employ, like a private security detail, to follow those conditions. And here's the final point. Combs is in a different position than Mike Jeffries, the former CEO of Abercrombie, who was recently also arrested and charged with federal sex trafficking crimes in New York. Why? The difference? The issue with Jeffries was less that he was a danger on the outside versus him being a flight risk. He has no criminal history. The allegation stemmed from a decade ago in that case, and he's 80 years old. And there was also no racketeering or RICO allegation like there is with respect to Sean Combs. So with all of that in mind, Judge Subramanian said no to bail. The bail request was denied. But now the question is, can Sean Combs get another shot with Judge Subramanian? Or what will be his likelihood of success in a different court? Because there's currently a pending appeal at the Second Circuit Court of Appeals. So to get into all of this, I want to bring on former federal prosecutor Neama Rahmani, friend of the show. Neama, thanks so much for coming on. First, before we even get into what he can do next, were you surprised by this decision by Judge Subramanian? Because you and I were covering this live when this hearing was happening, and we were floating the idea maybe the judge is entertaining the idea of pretrial release. Were you surprised the judge decided this?
Jesse, thanks for having me on the sidebar. As always, I'm not surprised with the decision. I'm surprised that Judge Subramanian entertained it. He held a 2-hour hearing, which we were covering live, and he issued a 5-page written order. Most other judges, including the 2 previous judges, to consider this issue, summarily denied the bail motion. I think a lot of it stems from Judge Subramanian being a newer judge. This is a Biden appointee. He has a civil background, doesn't have a whole lot of criminal experience aside from being a district judge. So I think someone with more experience would have denied this outright. Maybe he's slow, maybe he's very deliberate. But the fact that he entertained the defense's privilege motion, ordered the prosecution to destroy the 20 some odd pages of documents while he considered the in-camera review, leads me to believe that this is probably going to be Combs's best audience when it comes to this issue. And I don't think he's going to do better on a motion to reconsider the bail issue or on appeal to the Second Circuit Court of Appeals.
By the way, I have to tell you, I have been for the past year breaking down the legal arguments from both sides in the Sean Combs case, both on the civil front and the criminal front. And I have to say, every time I do it, it just always reminds me how important it is to have a great attorney on your side, right? And you know where that becomes so important? If you get injured. That can be such a confusing time and scary time. But the good news is we got Morgan & Morgan, our sponsor, our partner, America's largest injury law firm. They are experts in this field. They have an incredible track record, like recent verdicts of $12 million in Florida, $26 million in Philadelphia. These are higher than the highest insurance offers in these cases. And by the way, even if your case isn't worth millions of dollars, Morgan & Morgan will fight for what you deserve. There's no upfront fee with them. The whole process can be done straight from your smartphone. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar. First of all, from a legal point of view, I very much appreciated Judge Subramanian's questions because they were pointed questions, tough questions to both the prosecution and the defense. And I have to say, the fact that he was asking, well, where would home confinement be? And he rejected the idea of Florida and says, where else would it be? And then they came up with the idea of an apartment in New York and talked about what that would look like. It was very interesting to me. And I think he wants to be diligent. And he, in his order, he said he reviewed the record not only from that prior hearing, not only the briefs from both the prosecution and the defense, but he also reviewed the transcripts of the prior hearings, because there was a district court judge and a magistrate court judge, as you said, who both denied Sean Combs bail. So this was a 360-degree analysis. What I found really interesting was he didn't even entertain the question of risk of flight. The whole reason he denied Sean Combs bail was because of the dangerousness element, right?
I agree. And the risk of flight was always going to be a tough argument for the government because obviously Combs voluntarily came to New York. He surrendered his passports through his lawyer. He could have fled after the March raids of his Miami and Los Angeles homes, but he didn't. He has access to 2 private jets. I think it was a tougher argument. I know the government made the argument, but clearly the best argument was the dangerousness and the witness tampering. They had much more evidence with respect to those 2 elements.
How much was it with respect to Sean Combs' behavior versus his lawyers? There was a point in the hearing when his lawyer said, you can trust us. If we tell him not to do something, he won't do it. But as I mentioned, he kind of took, Judge Subramanian took issue with how the defense, their representations to the court, his court and another court, that they might not have been totally transparent about what was going on. Do you think that if this didn't happen, he might have been more receptive to Sean Combs' plea for bail? Why I say that is, let's say Sean Combs was to get completely different lawyers, right? Completely different lawyers. Could that change the analysis?
Potentially, but there was either outright misleading or attorneys who can't control their client. And one very important point in the judge's order was Combs was using PAC numbers and software to mask his phone calls as of recently, as of November 24th, even after the bail hearing. So that's something that the judge cited to, saying, hey, you're saying your client is no longer violating BOP rules and the MDC rules with respect to these phones, but he's doing it even after the hearing where you represented that this conduct would stop.
I've spoken to defense attorneys about this, and they said it's not a big deal if he's using other PAC numbers. It's not a big deal if he's using three-way call. And by the way, unless I'm wrong, and I don't think I am here, Judge Subramanian said I'm not going to address the actual content of those communications, whether or not he was engaging in witness tampering or he was even engaging in trying to taint a future jury pool, because he seemed kind of skeptical to that argument about tainting a future jury pool, because that allegation was about Sean Combs is having his family members post about his birthday and he's trying to change public opinion, and there was evidence that he really wanted to influence a potential jury pool. Judge Subramanian didn't, again, unless I'm wrong, didn't even entertain, it was more entertain that idea, and even getting into the content of it. It was he violated the Bureau of Prisons rules. If he's violating those rules, what makes us think that we can be assured he won't violate the rules of his bail? And I've spoken to, so A, correct me if I'm wrong there, but B, I would also say that multiple defense attorneys I've spoken to say everybody breaks those rules. That's not a sufficient enough reason for him to be denied bail.
Well, it's really important in this case because the case is going to come down entirely to that witness testimony, right? There is reportedly some video evidence of the freak off, so it's going to be interesting to see what they show. Obviously, we've talked about the 2016 video of Combs beating Cassie Ventura, but ultimately, the defense in this case is that this conduct was all consensual. So Combs is going to need the witnesses here, the victims, to go sideways at trial. How'd you like that pun? By the way. But so, the government's argument is that Combs is trying to threaten, blackmail, dissuade, even outright bribe witnesses to prevent them from showing up, or if they do show up, to take a very different position than they have in meetings with federal agents and potentially before the grand jury. They show up and they say that all this happened, but it was consensual. That's Combs's defense here, and that's apparently what he's trying to do through these communications. So it's not just, breaking rules, using someone's, this is actually a crime. This is witness tampering. This is obstruction of justice. If I'm prosecuting this case, and we've talked about this before, Jesse, I would supersede to add the sex trafficking of minors if there's obviously evidence of it. But importantly, the obstruction of justice charges, not because I think it's going to add any additional time to the case, but it's going to bring in all sorts of very bad evidence for Combs.
I was going to ask you if you think that, I was actually curious about whether or not if he was actually granted bail, if he was granted pretrial release. I thought prosecutors might hit him with a superseding indictment because they're already presenting evidence to a grand jury and say, okay, we're about to charge him now with more crimes, obstruction, perhaps some other sex trafficking related crimes, or amend the indictment to include these allegations to support the racketeering charge, because the racketeering charge includes a lot of different alleged illicit conduct, and say, we're going to add all of these allegations of obstruction, new charges. That's a way to get him back behind bars and get him, present this argument to the judge again. So, and now I am curious, do you think that it's possible they will hit him with a superseding indictment that will completely foreclose any opportunity he may have for bail?
I think so, and I certainly would. I think those are the two defenses I would anticipate, the witness changing their testimony or the consensual conduct. Again, I don't know what the video shows, but if I'm the government, I try to get out ahead of those two defenses, because really it's the only possible way that you lose this case if, the witnesses go sideways here.
Let me go back to the Second Circuit. So correct me if I'm wrong. He had appealed to the Second Circuit. he actually put that on pause. He put it's called abeyance. Let Second Circuit, I know I'm appealing this bail issue to you. Put it on pause. I want to go to Judge Subramanian. We haven't argued this bail issue in front of him yet. Let's see what happens there. If that's not successful, we're going to go back to the Second Circuit. What is the difference between what Judge Subramanian just decided and what potentially the Second Circuit could decide? Is there any way they would be more sympathetic to Sean Combs' bail arguments and ultimately grant him bail? Talk to us about how that would work.
It's certainly possible, but in these types of cases, appellate judges are really supposed to defer to the discretion of the trial court. They're the ones who hold these types of hearings and they make decisions. Now, obviously, if there's an abuse of that discretion, they can reverse, but that's very uncommon in my experience, where an appellate court will step in and say, you know what, the denial of bail is an abuse. We saw it in the DC circuit with respect to some of the Capitol rioters. So it does happen, but it's not very common. So I would be very surprised if the Second Circuit 3-judge panel steps in, especially when one magistrate judge, now 2 district judge, Carter and Subramanian, and even pretrial services. Let's not forget, they're an arm of the court.
Right.
They come in with their recommendation, and their recommendation the whole time has been detention. So everyone, aside from the defense, has ordered or recommended that Combs be detained. So I'd be surprised if an appellate court disturbs that ruling.
And the circumstances got worse for Sean Combs. The allegations are worse now with these allegations of witness tampering from behind the MDC. That didn't happen yet with respect to Judge Carter and Judge Tarnowski, because they had already decided Sean Combs was a danger to society and a risk and obstructive. And now you have all this new evidence for the prosecution. But what I do think is interesting is what you said with the Second Circuit. They would be reluctant to overturn the trial court's decision. Maybe that's why Judge Subramanian was so meticulous and took his time, so that the defense can't say, oh, he just so easily dismissed our claims. He decided it in one day. No, he took his time. And yes, he waited till the eve of Thanksgiving to announce it, but he basically did a thorough review, and it might be more difficult for the defense to ultimately say that he wasn't fair. But going back to Subramanian, what could be a change of circumstances that that he would review the bail condition, unless, I don't know, Sean Combs' defense attorneys can raise the bail issue every week if they want. What would be a change of circumstances that he would actually revisit this issue and maybe have a different point of view?
I think it's very unlikely. We're about 6 months away from trial, and something would have to dramatically change in terms of counts being dropped, witnesses, again, not supporting the allegations in the indictment. And really, the only one that's identified so far as V1 is Cassie Ventura. So I don't know how a change in the evidence would support. And like you said, it just keeps getting worse for Combs. He's his worst enemy. And we say this all the time for criminal defendants, right? How many times do these jail calls come into evidence in the cases we cover here on Law and Crime, right? Even though the inmates are informed in writing, and even at the beginning of their phone calls, if their calls are recorded, they still make these phone calls, make admissions that can be used against him, or in this particular case, engage in alleged witness tampering. That's going to be a problem for them.
Let me ask you this. You go to victim 1, who we believe in this indictment in these papers is Cassandra Ventura. The defense was keen to suggest, look, I know the prosecution is saying that 2016 videotape is evidence of him trying to prevent her from leaving a freak off, that it's evidence of sex trafficking, evidence of his dangerousness. The court also cited these text messages from victim 1 to Sean Combs, where it was the hours and the days following the 2016 attack at the Intercontinental Hotel, where she allegedly writes him, or this victim 1 writes him, I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. To, again, further evidence of his dangerousness. The defense spent a lot of time to saying, we can show you a different context of this. This is not to support sex trafficking. It's just a toxic relationship. It's a violent, long-term toxic relationship. The judge was not persuaded by that. And I don't know if it's that's not the issue for this bail analysis. Maybe that's for a trial. You talk about her credibility. You try to defend against sex trafficking. This is more about evidence of his propensity for violence. So just to be clear, even if Sean Combs' defense counsel produces all this evidence to say there's a reason he was violent with her, or there's a reason to suggest there was a toxic element to this relationship, that wouldn't be enough to change the court's mind regarding Sean Combs being dangerous, right?
Not at all. And with respect to the video, the defense has said a lot of things that I don't think are true. One is that DHA agents, they intentionally leaked this video to try and taint the jury pool. Well, we know CNN got it from an independent source at the hotel. And they said that the video was edited. But for me, the most telling fact is this with respect to the video. Combs, through his lawyers, denied these allegations for months, approximately 6 months from the time Cassie filed her lawsuit in November 2023, even after the raids, right? The lawyers said this is all extortion, this is all about money, this is a shakedown, none of this happened. But guess what? In May, when that video was released and CNN airs it and we all see it, Diddy comes out and he issues an apology. I don't think it was a very genuine apology, but that's how powerful the video is, Jesse, because people can lie, defendants, defense attorneys, even prosecutors can lie, but that video doesn't lie. We've all seen it. It shows the propensity for violence. And that's exactly what Subramanian quoted in his order.
What about another potential avenue for Sean Combs to revisit the issue if the conditions at the Metropolitan Detention Center get so bad? We've talked about this before, how the MDC is plagued with violence and health issues. And there was even an example of a judge who refused to sentence a defendant to prison if he knew that the defendant was going to go to the MDC. The reason I bring that up is this is what Judge Subramanian said regarding the MDC. The court also finds that Combs has not shown that a temporary release from detention is warranted. And then he cites a statute. He says, under this provision, a judicial officer may permit the temporary release of the person in the custody of a United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Combs' application is based on the conditions at the MDC, which he says make trial preparation impossible. But given Combs' access to counsel and documents, there was an issue with Combs receiving a laptop for the purpose of reviewing discovery. But the court addressed that. The firm deadline for the government's discovery, the end of this year, and the time left before trial over 5 months, Combs has not carried his burden of demonstrating that release from detention is necessary for trial preparation purposes. But the court will promptly address any issue that arises with respect to Combs' trial preparation, and if the circumstances materially change, he may renew his application. Neama, talk to me about that.
Well, Combs is separated from the general population, right? He's with, or was with Sam Bankman-Fried at least. And the irony there is that's someone who was granted bail, tried to tamper with witnesses, so the judge revoked his bail. So that just goes to show how these federal judges feel about witness tampering before trial. You know, Combs obviously has access to the legal pads. I know there was some question of this laptop, and the government has been a little bit slower in extracting this data. We're talking about terabytes of data and getting it to the defense. They promised to have it all done by the end of the year. And of course, Combs will have access to all that subject to the protective order. So to the extent that Combs has access to his lawyers in person, phone, clearly is able to communicate with them with those pads, I don't see how he's treated any differently than any other federal criminal defendant. So I don't think he's going to qualify for release based on changed circumstances, because guess what? And everyone should probably be released from the MDC pending trial.
Well, I guess his argument would be this is such a massive case. It's a complex case. There's so much data, and he might have a target on his back. He's a celebrity. I mean, what would be an example of a changed circumstance that Judge Subramanian would say, home confinement, there's something going on at the MDC, it's too much of a problem? What would something like that look like?
Potentially, if he's attacked in prison and the guards aren't able to keep him safe, maybe that's something the judge would consider. But again, I think he's probably in the safest place he can possibly be. If there are conspiracy theory types that think that, you know, this is another Jeff Epstein type situation where Combs knows information about sex trafficking at the highest levels and he may be killed. And if you really believe that, well, what safer place to be than in federal custody? How safe is it on the outside?
All right, well, Let's see what happens. If he loses at the Second Circuit, I don't know if you know this question, can he appeal that to the Supreme Court? I mean, what's his other option if the Second Circuit says no to him? Can he go anywhere else?
You can potentially appeal to the Supreme Court, take a writ. Obviously, the Supreme Court takes very few cases, accepts a very small percentage. I would be shocked if they decided to dive into a bail issue like this. They have bigger fish to fry.
The only thing I could think of, have you ever seen a case like this where somebody has the ability to present such an expansive bail package? In other words, not everybody can afford $50 million bail secured by home equity, private security firm, no phone or internet access. If you could present such an expansive and expensive bail package in your mind that would address every single issue that the prosecution has because of your wealth and your power and your resources, is that a little bit of an unprecedented issue with Sean Combs? Have you ever seen a private security being used by a defendant like this? Is this a novel issue that maybe could be decided by the Supreme Court? I might be stretching here.
Well, the security issue is novel, but we have seen bail packages like this in complex fraud case. And again, Sam Bankman-Fried, massive bail package, the largest, I believe, at least reported in a federal criminal case. So we have seen it. We have seen some rich defendants out on bond pending trial, and even cases that are more complex than Sean Combs. We're talking about massive frauds and accounting issues and dozens, sometimes hundreds of witnesses. So I think what Sean Combs, it's unprecedented in terms of the extent of the sex trafficking and the number of victims. We certainly haven't seen that, certainly with someone of his wealth, but I don't think he's any differently situated than these other very high profile criminal cases that we've seen.
All right, so it was definitely a blow to him. It was a blow to his defense counsel, blow to his family, and barring some sort of change of circumstances, it looks like he is going to remain behind bars pending trial, but we'll see what happens. It's always been a shocking case from the very beginning. We'll see. Neama Rahmani, thank you so much for taking the time. Great seeing you.
Thanks for having me, Jesse, as always. And I think one last point, I think this is going to push the case to trial even faster because I think Combs is not going to want to continue this while he's in custody.
Well, I'm glad you mentioned that real quick, because I was under the belief, I agree with you, that when I think he never thought that he would lose bail. I think he always felt he would make it. And as soon as he found out that he wasn't going to be granted bail, tried to push this trial, as soon as possible, because he doesn't want to be locked up there. But I mean, if you go in and you're rushing to trial, but with you're not fully prepared, either A, he really believes he's going to win this case, no problem, or B, I mean, the other way of looking at it is he's currently locked up potentially till May, his May trial. But if he's found guilty, there's a chance he will never get out. So I'm just curious, why the rush? If really what he's looking at is potentially the rest of his life in prison, shouldn't he take the time to be as prepared as possible?
I'm sure he's going to want to prepare his defense, but if he were out on bond, believe me, he would be taking his sweet time. The lawyers would say,
of course.
Yeah. Well, we would probably wouldn't have a trial until 2026 at the earliest. The defense would ask for additional time, say we can't prepare. There's so much electronic evidence and data. We got to interview dozens, maybe 100 witnesses, people that have come forward. So. And of course, knowing this judge, knowing how deliberate he is, I wouldn't be surprised if he granted those requests. So, yeah, obviously, he's going to want to prepare his defense, but I think that's going to be very different than the Combs defense and the delay strategy that would take place if he were enjoying freedom like the rest of us.
And by the way, if he's hit with a superseding indictment and it includes additional charges, let's say with respect to minors, that whole bail analysis changes completely as well. All right, Neama Rahmani, now I will say so long to you, but great seeing you. Thanks so much for taking the time. Really appreciate it.
Thanks, Jesse.
All right, everybody, that's all we have for you right now here on this episode of Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.